So, good morning to everyone, and welcome to this webinar that we are offering from EQS Group together with our partners from KPMG Law, KPMG. So, I hope you're having a great day so far, and thanks for joining us and being part of this webinar for the next 90 minutes. I think we have an exciting topic again. So it's already the third webinar in a row around the EU Whistleblowing Directive. And as you can see today, it's called Transposition Status EU Directive Part 2. So this indicates already that we had Part 1 a few weeks ago, trying to give and provide a good overview on the transposition status amongst the member states and where they are in detail. And besides the overview, we had a focused view on some of the member states, and we will continue this today. So there will be an updated overview. Where are we looking at all the 27 member states? And we've again picked up 5 countries to take a closer look at, but this is what you'll see in the course of this webinar. So beside myself, I will be moderating. We again have kind speakers from KPMG Law. So Bernd Federmann and his team are the experts that will provide a lot of information, a lot of expertise during this webinar to you. And they will introduce themselves when they have their part later on in the session. Maybe just a few hints regarding the logistics. So for those who participated before, you should already be familiar. For the others, maybe most important, if you have any questions, just use the chat function within the platform, so you can drop a question to us, and we will receive the question and we'll sort questions and then pick them up in our Q&A session at the end of the webinar. Yeah? So any question will be seen, and we will see that we get answered as many as possible. Also, there is a download available within the platform today because we just published together with KPMG a white paper on the topic that is available for you as a download within the platform. So, and if you should be having any technical issues, also drop us a short note via the chat, and we will try to help you as good as we can. But now let's enter into the topic. Still exciting times, and I'm quite sure this will keep all of us busy for the next weeks and months still. So the EU Whistleblowing Directive and the transposition, as you know, some countries are still quite away from transposing. Some others have done their homework and have already transposed, and there is and the rest is somewhere in between in different stages. So always good to look at this, and especially for those of you who might be let's say, in an organization that is active in 2, 3, or more of the EU member states, it's going to be quite challenging to keep overview, and we will try to provide this overview to you. So before we start this, we have actually prepared a short poll question for you that I'm now opening. And we would like to really invite you to just give us an idea. So what is the status of the implementation of the Whistleblower Directive and the related requirements in your company / organization? So first option would be you have a whistleblower system in place already for some time that meets the requirements of the directive. You might have a whistleblower system in place already, but it does not yet, in brackets, fully meet the requirements of the directive. You might have a whistleblower system, but not have a whistleblowing system, but you're waiting still for the national legislation, so for the transposition in one or a few of the member states. And it might even be that you're not really sure about if you have to implement a whistleblower system, yes or no, and how it should be configured. Yeah? So these are the 4 options. You're kindly invited to vote here, and I'll give you, let's say, half a minute to a minute to just collect the answers, and then we can look at the results. And this will also give an impression who's in the audience and how far you are or where in the process you currently are. So we'll wait for a few more seconds. So we are at roughly half of the participants. Just click the option that is the correct one for your company, for your organization. And as I can see in the chat, there is a comment coming in. We're missing one option in the poll, and the option would have been no system in place yet, but planned in short time frame. So happy welcome, and this would anyhow be a recommendation. Thank you very much for this. All right, so let's look at the results together and get an impression what we have here. So as we see, quite interesting, roughly a third, or maybe more or less exactly a third of the participants have chosen that they have a whistleblower system in place and it meets the requirement of the directive. So I hope it's not going to be too boring for you, because if you're already prepared and set up, you're more or less done probably, but might be that you learned something during the course of this webinar today that would lead to at least smaller adjustments. And then we have 43% having a system in place, which is good, but and this is what we really observe talking to many of our customers these days, that they see the need for some further adjustment depending on the requirements of the national transpositions. So this is going to be very interesting for you, for all of you who have answered with option 2. For sure. And number 3, yeah, very interesting still, 20%. So 1 out of 5 is saying we do not yet have a whistleblowing system in place and are waiting for the national legislation. We'll for sure talk about this also during the webinar. Recommendation will quite for sure be to anyhow start moving forward, because the legislation is going to come, and you will need to do something. And luckily enough, which shows that most of you are obviously quite well informed already on the topic. So only 2.5% are saying you're not sure if you have to implement a whistleblower system. So we'll shed some light on this as well during the course of this webinar. So thanks for participating, and with this, I would really like to hand over to Bernd Federmann from KPMG Law. Bernd, it's really a pleasure to have you and your team on this webinar here again. Thanks a lot for providing such great expertise to these larger audiences and to all the people who are interested to learn more about what the directive means, how to set up, where the member states are. So over to you.
I thank you very much. Yes, many thanks, and also welcome to the audience from the side of KPMG. My name is Bernd Federmann, partner with KPMG Law in Germany and with focus on compliance advice. Today, the colleagues of the KPMG Integrity Service Network want again to give you an overview over the current status of transposition of the directive into national laws throughout all 27 member states. The KPMG Integrity Service is a global network of more than 70 independent KPMG country offices They are all specialized on legal and forensic advice on all topics around whistleblowing. And we do this together with our alliance partner EQS Group very successfully. So I think we can go to the next slide, please. The EU directive on the protection of whistleblowers requires all organizations with more than 50 employees, as well as the public sector, to set up internal reporting channels and a case management system to report processes violations, and also external channels. And here you can see the agenda of today's webcast. The EU Whistleblowing Directive is expected to be largely implemented and transposed into European member states within the course of this year. As we heard before, it has taken place in every country. Ariane Loof and Andreas Brucksch will give us a high-level overview over the situation in all the member states where the directive has already been transposed, where there exists a draft law, and where nothing has happened so far. And then we will have some deep dives into the situation of Belgium, that is done by Gert Kavenberg, of Italy, that's to change, we are in the alphabet, that is done by Giulia Cantini, Germany, done by myself, Spain, done by Almudena Guerrero, and the Netherlands, done by François Coppenol. At the end, EQS will present the system, if there's time enough, which is technically able to cover all these legal requirements. The colleagues will each shortly present themselves when starting their contributions. And the presentation will, after this webcast, be sent to you upon request, as usual. So we can go, I think, to the next slide, please. The status of transposition of the EU Whistleblowing Directive that varies across the EU member states. Here you can see on the map of Europe how it looks like. The members of the global KPMG Integrity Service Network have prepared a white paper with an overview of the current transposition status in each member state, including all the advice on the local specifics. That is the edition May, the second edition, May 22, and will be published this week also. And that is what Jens has already mentioned. EQS has prepared a respective white paper, and KPMG itself is very happy that we have had the chance to largely contribute to this EQS white paper, and it is also already in course of publishing. So the details of the member state situation are now outlined by my colleagues, and I'm happy to hand over in the first section to Andreas and Ariane. And then we can go to the next slide, please.
I say hello to you at first. It's Ariane Loof from KPMG Law in Berlin office. I'm a lawyer on data protection law, and I'm happy to give you a brief overview over the transposition status in some countries, and wait for my colleague Andreas.
Yeah, I was on mute, sorry for that. Thank you very much, Ariane. My name is Andreas Brucksch from KPMG Law in Germany. I'm an employment law expert, and I'm currently involved in many projects to implement whistleblower systems in companies. And as Ariane Loof mentioned, in the next few minutes, we will give you a brief overview of the implementation status of the EU countries, which our colleagues will not go into in detail at a later stage. We will start with a few countries that have already implemented the EU directive. In Cyprus, the directive was transposed into national law in February this year. In addition to that, or in addition to the reporting topics of the directive, this law provides for further reporting topics such as criminal offenses, including corruptions, non-compliance with any legal obligation, violations imposing danger to security or health of a person, Anonymous reporting of violations and reporting by email are permitted. And for companies with 50 to 249 employees, the law does not have to be implemented until December next year. The penalty for violations is up to 30,000 euros.
Then I will continue with Croatia, give you a brief overview of the transposition status in Croatia. Croatia has already transposed the whistleblowing directive to national law in April this year. This law provides also for additional topics to be reported, national law and criminal offenses. The anonymous reporting is permitted, as well as email reporting is permitted. Companies under 250 employees can share, so centralize internal reporting channels. And the fine for any violation is quite low, up to 4,050 euros for legal entities. And then next slide, please.
Denmark has also already transposed the directive. The law is in force since June last year. For small companies with 50 to 249 employees, the law does not have to implement it until December next year. And the law allows a corporate group to set up a shared whistleblower scheme, which cover all subsidiaries within the group. The whistleblower channel must be available to all employees, and an email reporting is not prohibited as a reporting channel.
Okay, so then I will take over for France. France has already transposed the whistleblowing directive into national law, and already in February this year. The whistleblower may either use the internal whistleblowing system or the competent external authority, as in the most countries. The law provides also for additional topics to be reported. They don't need to qualify as serious or obvious anymore. All violations might be reported now. The fine amounts up to, the fine for delaying or abusing measures is up to 60,000 euros, which is quite high. And a person who discriminates a whistleblower may be subject to a fine up to 45,000 euros. The companies with less than 250 employees can centralize their procedure for collecting and processing reports, and no sanction is planned for not implementing a whistleblowing system. Then I will hand over to Andreas again for Lithuania. Sorry.
In Lithuania, the directive was also transposed in February this year. In addition to the reporting topics of the directive, any violation of the law in public interest can also be reported. And special feature is that private legal entities with less than 50 employees must implement internal reporting channels if their activities relate in particular to consumer and investor protection, or to the financial and insurance sector, to the transport sector, or to environmental protection. The anonymous reporting and reporting of hints via email is also allowed. So we can hand over to Latvia.
Latvia has also already transposed the whistleblowing directive to national law in February this year. The transposition law largely follows the whistleblowing directive. However, there are additional topics to be reported that can be reported: the violation of national law and criminal offenses. Anonymous reporting is not prohibited, which means it's not mentioned that it's permitted, but it's not prohibited. But however, anonymous reporting persons are not protected, and they are not entitled for any investigation of their reports. The email reporting is as well permitted. Companies under 50 employees can share internal reporting channels, The whistleblowing system can be outsourced to third parties, as in most countries. Fines for violation amounts up to 7,000 euros. And next slide, please.
In Portugal, the law was transposed in December last year. However, it will not enter into force until the 18th of June of this year. In addition to the reporting topics of the directive, violent and severely violent criminality, organized crime, and economic and financial crime are additional reporting topics. Fines for violation may reach 250,000 euros. So we can hand over to Malta.
Malta has already transposed the whistleblowing directive last year, December last year, to national law. It also provides for additional topics to be reported, as it is any violation of national law, including criminal offenses. Anonymous reporting is not prohibited, but as mentioned before, for the other country, it's anonymous reporting persons are not protected. Email reporting is not prohibited, and companies under 250 employees can share their internal reporting channels, and we have no information on fines. And then next, now Sweden, please.
The law in Sweden is in force since December last year. Small businesses with 50 to 249 employees do not have to implement until December next year. The law has a wider scope than the directive. Violations that affect the public interest can also be reported, and entities with 50 to 249 employees may share internal reporting channels with other group entities with less than 250 employees. And then anonymous reporting is not prohibited. On the next slide, we come to the countries where the directive has not yet been transposed, but there are already draft laws. In Belgium, for example, there is such a draft. My colleagues will go into more detail on this at a later stage.
So we can give an overview on Bulgaria. Bulgaria has not yet transposed the whistleblowing directive to national law, but a preliminary draft has been published in April this year. The implementation of this national law is not expected until mid of the year. However, it's expected the new law will probably have some additional topics to be reported as crimes of a general nature. Companies between 50 and 249 employees are allowed to centralize their reporting channels. Anonymous reporting will not be prohibited, and the fine for any violation will amount up to 10,200 euros.
In Czech Republic, a draft was published in April 2022. According to the current wording of the draft, it is supposed to be effective as of the 1st July 2023. And in addition to the reporting topics of the directive, information on possible unlawful act which has characteristics of a criminal offense or violates Czech law regulation can also be reported. And the anonymous reporting should not be prohibited. And the fines for violation range up to 41,000 euros or 5% of the obliged entity's net turnover.
And then we go to the next slide.
To the next slide, please.
To Estonia. Estonia as well has not yet transposed the whistleblowing directive to national law, but has published a preliminary draft, who has already passed the parliament in January this year. The implementation is expected in June this year. The draft law largely follows the whistleblowing directive. However, in Estonia, there are no reports on violations on employment relationship issues and state secrets allowed. The anonymous reporting is permitted, email reporting is permitted, and group companies can share their internal reporting channels. The fine for any violation will amount up to 400,000 euros for legal persons and up to small fine 1,200 euro for natural persons.
A draft law also exists in Finland. It is expected to come into force in the fourth quarter of 2022. A centralized whistleblowing system and process is allowed. No penalty is provided for non-implementation. The risk of losing the information advantage for companies that is possible through an internal reporting channel, and the risk of not being able to benefit from liability relief are considered sufficient. In Germany, on the next slide, please. In Germany, a draft law also exists since April 2022. My colleague will go into more detail on this at a later stage, so we can hand over to Luxembourg.
Yes, Luxembourg has not yet transposed the whistleblowing directive to national law, but has published a draft law in January this year. We have not much information on this draft law, but however, we have the information that it will largely follow the EU whistleblowing directive, and the anonymous reporting is permitted, will be permitted, the email reporting will be permitted, and we have no information on fines yet.
In Ireland, a draft was published in February this year. The transposition is expected in the second quarter of this year. The violation of competition law, state aid law, tax law, and public procurement law should be additional reporting topics. Anonymous reporting should not be prohibited, and companies with 50 to 249 employees will not have to implement the system until December next year. And the penalty for violation is up to 250,000 euros, and for natural persons, also imprisonment of up to 2 years is possible. On the next slide, please.
On the next slide. Then we come to Romania. Romania has not yet transposed the directive to national law, but has published the draft law in November last year. The implementation is not expected. We have no information when it is expected. It was not expected in the spring. The anonymous reporting is permitted, will be permitted. The email reporting might be prohibited. That is expected. The fine for any violation will amount up to 10,000 euros for legal, for companies, and natural persons up to 300 euros.
In Poland, a law bill was published in October last year.
Ik zit ook in een webinar, dus ik luister even met een half oor ook live webinar. Dus dat hoor je wellicht op de achtergrond. Maar ik moet daar wat dingen zeggen, maar dat is pas om 11:15.
François, can you go on mute, please?
May you please go on mute?
In Poland, a law bill was published in October last year. According to this, legal entities might amend additional reporting topics to other violations of national law and/or internal regulations and ethical standards. The anonymous reporting and the reporting by mail should not be prohibited. Companies with 50 to 249 employees will not have to implement the system until December next year. And the penalties for violations are according to the Polish Criminal Code. For natural persons, imprisonment up to 3 years is possible. So we can go to the next slide, please.
Next slide. To Slovenia. Slovenia has not yet transposed the directive to national law, but the draft law was published in December last year. The implementation is expected mid of this year. Anonymous reporting will not be prohibited. Email reporting will not be prohibited, so permitted. The fine for any violation will amount up to 6,000 euros.
And in Slovakia, the draft law has not yet been passed by Parliament. The transposition is expected by May this year. In addition to the reporting topics of the directive, violations of national law will also be possible as an additional reporting topic. And until the transposition, the directive shall be directly applicable to state legal entities, departments, and other public corporations. And anonymous reporting should not be prohibited. And violations can be fined up to 20,000 euros. So we can go to the next slide, please. In Spain and the Netherlands, draft law already exists. My colleagues will go into more detail on this at a later stage. So we can go to the next slide, please.
Then we come to the countries who has no draft law, or the draft law has not been published officially yet. So at first, Austria has not transposed the law, and the official draft law has not been published yet. However, there are some information. The implementation is not expected until July this year, and the European Commission has initiated already an infringement proceeding against Austria. The existing working paper discusses some information about anonymous reports, the extension of scope of topics that can be reported. The implementation deadline for small companies is expected to be December 2023, and companies with fewer than 250 employees might be entitled to delegate the management of the internal reporting channel to a joint unit, so centralize it, and we have no information on expected fines yet.
In Greece, the first draft is expected at the end of the second quarter of this year. And so we can go to the next slide, please.
There's Hungary. The Whistleblowing Directive has not been transposed yet. There's no draft law published yet. The implementation is not expected. Was not expected in spring, and is probably not expected until mid of this year. But however, they have a current law on the protection of whistleblowers, and the current law includes provision on whistleblowing procedures, mandatory for public bodies and local government bodies. Under the current applicable law, the anonymous reporting is permitted and the email reporting is permitted as well, and we have no information on fines. So the last country is then Italy, which will be presented by our colleague in a later stage. And now I will hand over to my colleague Gerd for the presentation of the transposition status in Belgium.
Okay, thank you very much. And the status in Belgium is that the EU Whistleblowing Directive has not yet been transposed in Belgian law. There currently exists a preliminary draft, which was, it exists since July 2021. In November last year, we also received the advice from the National Label Organization and the Central Council for Business on that preliminary draft. And it was at that time foreseen that the text or the law would be adopted in Parliament before the summer. However, currently they're facing some delays. The advice from the data protection authorities, for instance, has not yet been received, and from the Council of State. So according to our sources, they'll probably be looking to introduce the draft bill in the Parliament somewhere before the summer, but the voting process will probably take place after the summer recess of the Parliament. And then I gladly give the floor to Valerie, who can shed a little bit light on what's already in the draft law.
Thank you, Gert. So indeed, I will give you an overview of some main characteristics of the preliminary draft. So in which way does the Belgian text, the Belgian preliminary draft, provide for more of extent the protection in comparison actually to what is provided for in the directive, because as you all know, it's a minimum harmonization directive, so the national legislators can extend the protection. First of all, the material scope. So as you may know already, the directive provides for 10 areas which fall within the scope of the directive, within the scope of the protection. For example, consumer protection and transport safety, and also a number of other areas. And in addition to the list of 10 areas, there's also per area. The directive also provides for a list of union acts, meaning that per area they enumerate the list of directives and a list of regulations which do fall within the scope. So this means that if a person would report on a certain breach, he would be protected if it falls within the 10 areas, but it additionally also should fall within the union acts which are explicitly enumerated in the act. So now the Belgian text extends the material scope in two ways. So first of all, the text provides for the 10 areas which are also provided for in the directive, but then there are also two additional areas, namely fight against tax fraud and against social fraud. And secondly, the Belgian text also does not foresee that it should fall within the union acts enumerated. So in this way, it's also the scope is also broader than the scope of the directive. Then, as to the temporal scope, so the entry into force, Gert already mentioned that there's some delay in the legislative process. So normally we expect the law to enter into force later this year, but for the legal entities in the private sector with less than 250 employees, as also foreseen in the directive, there will be some additional time to comply with the rules until the end of 2023. So that's also provided, similar to what is provided in the directive. Then additionally, which entities have to set up the reporting systems? It will be the legal entities in the private sectors who employ more than 50 workers. So here, it's also similar to what is provided for in the directive. And for the, how should we now calculate this threshold, because this is not provided for in the directive. Here, it's the national legislator who should specify this. And in Belgium, the preliminary draft refers to the social regulations. We will look at a certain number of employees which are employed within a certain period of time. So there, reference is made to other existing laws. Then further, anonymous reporting should be enabled. So the private entities in the entities in the private sector employing less than 250 employees, but also the public authorities who will be competent to follow up on the external reports, they should not only receive anonymous reports but also follow up on these. So this should be possible. Then, as to the type of channel, there's some flexibility. On my slides, I indicated that social consultation, so a consultation with the representatives of the employees, is recommended, but no obligation. But now it seems that they're moving in a direction of actually obliging entities or to have to set up the channels and to set up the reporting systems in close consultation actually with the representatives of the employees. But as I already mentioned, it's just a preliminary draft, meaning that it's still subject to changes, and we'll have to see in which direction that the legislator will move. So that was the update from Belgium, and we now hand the floor to our colleagues from KPMG Germany.
Yes, Thank you very much. Yeah, the EU Whistleblowing Directive has also not been yet transposed in Germany. However, since April, thank you very much for changing the slides. Since April, a new draft law of the Federal Ministry of Justice is currently in the regular legislative process. And it is expected that the new German law will come into force in autumn 22 at the latest. That means in the third quarter this year. At the moment, the association hearings are taking place at the request of the Ministry of Justice. For example, the German Institute for Compliance, Amnesty International, other associations, and inter alia also KPMG Law was asked to submit comments on the draft, which we did last week, as the others. These comments are published and then discussed, and then be put into the final version. The obligation to set up internal channels applies to both the private sector and the entire public sector, provided that the organization respectively employs more than 50 people. And as we heard from Belgium, the material scope goes beyond one-to-one transposition. The same here. This is, as in the other countries, for avoidance of contradictory interpretations or valuations. And that was in particular also the casus knacktus, according to which the first draft in last year did not become a law. The draft includes especially all violations that are criminal law offenses. Additionally, violations that are subject to administrative fines, and this irrespective of their EU origin. This applies in particular if the violated provision serves to protect life, health, or the rights of employees or their representative bodies. Whistleblowers are free to choose whether to report to an internal or an external channel, the external channel of the state. The central external federal reporting channel will be by the Federal Office of Justice. And it is in discussion if the whistleblower should be forced before for the proposed to be protected first to go to the internal channels and afterwards, if there does not, they come not to a solution there, give their hint to the external channel. That is under discussion at the moment. First internal, then external. Now it is parallel possible. The due date of implementation is for the private companies at a later stage, which are only 50 to 249 employees. That is 17th December 23. There, it's open. The directive is open to set up this later implementation date, and that is what the German legislator wants to do. And to mention, due to the expiry of the transposition deadline of the EU whistleblowing directive, that is also so that the public sector might already be obligated to implement such whistleblowing systems due to the relative narrow and detailed requirements in the EU directive. So that is currently the question at the moment before the law gets into force with respect to the public sector. And the draft law provides various safeguards for whistleblowers in accordance with the directive requirements. Central element is prohibition of reprisals like disadvantages, like dismissals, warnings, disciplinary measures when giving a hint, but also damage to reputation and mobbing. And the burden of proof is on the side of the company, and not on the side of the whistleblowing for this. And that is also given by the directive, but in question at the moment in the legislative process. Yeah, then the draft provides only for a few regulations regarding the design of the whistleblower system, like it is given in the directive. But one thing to mention, we have Section 7, and there is no obligation to design internal reporting channels in such a way that they enable the submission of anonymous reports. Also, Section 27 of the draft does not require external, also the state reporting channels, to process anonymous reports. However, an essential prerequisite of success of a reporting system is the possibility for anonymous reporting. And the annual benchmarking study of EQS Group shows that more than 50% of initial reports are submitted anonymously, and 75% of the whistleblowers set up a mailbox or anonymous communication with the receiving office. And that is to be taken into account. And this also reflects the high level of uncertainty that the whistleblowers have. Because often it is not only the protection of one's own identity that demands anonymity. So it's also a lack of, I think, trust in the downstream processes and so on. And according to this benchmark study, 2/3 of whistleblowers are willing to give up their anonymity when they go and further handle the case. And we have to say, with regard to sector-specific regulations in Germany, the Financial Service Supervision Act will foresee that the Whistleblower Protection Act in Germany also applies with the provision that the reports in the financial sector may also be submitted anonymously. And against this background, the lawmakers are rethinking at the moment if they should perhaps implement anonymous possibility also in Germany. That is what is in question at the moment. And for example, Transparency International also underlines this. Yeah, the new draft allows companies, regardless of they are in a group of companies, up to 249 employees to work to have joint whistleblowing offices and case management. And in addition, the German draft law makes it possible to centralize whistleblowing channels in a group of companies, irrespective of the size of the group company. And that is criticized by Transparency International, for example, but it is also welcomed by the German Institute for Compliance. And in our opinion, it makes sense from a practical point of view to have such a regulation. It is not contained in the text of the law itself, but in the explanatory notes of the law that foresees this. Yeah, the implementation then afterwards of the whistleblower system can trigger participation rights of the Works Council, but that is not outlined in detail in the respective law. And the draft law does also not include special data protection regulations. In this respect, you can think about the solution like it is in Austria to implement some clarifications, perhaps, that might make sense. And at the end, violations of essential requirements of the law can be punished with administrative fines, not as criminal offenses. This applies, for example, if you fail to set up an internal reporting channel that can cost you up to 20,000 euro. And furthermore, you have fines for heavy violation of the respective obligations contained in the new law, which may cost you more than 100,000 euro per case. However, as it was with GDPR, we do not think that in the first year height of the potential fines will be in question. That will come from year to year to year. So this is a short overview, and I will go and hand over to Giulia for Italy. Thank you.
Thank you, Bern, and good morning, everyone. I'm Giulia Cantini. I'm a lawyer, and I work as senior manager in the Governance and Compliance and Organization Department of Studio Associato, KPMG Studio Associato, and I deal with compliance and governance matter, and in particular with the focus of criminal corporate liability, and I'm also responsible of the whistleblowing matter for our private companies. In Italy, as you can see, the European Directive has not been transposed yet, and at the moment, unfortunately, we do not have an official draft law. In April 2021, the Parliament delegated our government to issue a decree law on the matter, but unfortunately the deadline to adopt the decree has expired, and in December 2021 a new delegation has been approved and now is under the final approval of the Senate. So we do not expect for sure by the end of the second quarter of this year to have a draft law, most probably by the end of this year, also because there is a great pushing of some organizations like Transparency International, the Good Lobby, and also the Ministry of Justice is engaged on this task. Let me say that nevertheless, there is no draft law. In Italy, we already have several laws that regulate the whistleblowing matter. The system of reporting possible violation and possible crimes has been introduced in our legislation 10 years ago in the public sector with the so-called anti-corruption law. The system of reporting at the very beginning was not exactly welcome because these measures, as a preventive measure against corruption, was seen with doubt and distrust. Our culture was not very familiar with such instrument, and the system was not properly regulated in details. And most important, the whistleblower were not sufficiently informed about the protective measures. So in 2017, the legislator introduced an amendment to the anti-corruption law to better detail the features of the reporting system and to reinforce the protection measures. And with the same law, the whistleblowing reporting system was also introduced in the legislative decree 22101, that is our corporate criminal liability system. So from that day, private companies that adopted a model to prevent certain crimes according to the legislative decree, including corruption, are already required to adopt a whistleblowing system, assuring multiple channels of reporting, also by informatic tools and specific protection measures to protect the whistleblower from retaliation. So at the current, even if we do not have a draft law and the directive has not been transposed, we have several provisions, both for public and private companies. Here, I represented some of the main challenge that I think arise from the transposition of the directive. First of all, we need to coordinate the current regulation that has is already significant for private and public sector. And in addition, our legislator shall define the material scope identifying which are the breaches of the union law that are relevant from a whistleblowing perspective. And this for sure will increase the scope of the whistleblowing reports compared to the one we have now in force. And there will be also many cross-reference with the legislative decree 231. Other key factor will be also the necessity to design and define the feature of the measures to protect the whistleblower, to protect the confidentiality, and to grant the anonymity. In our legislation, the anonymity is possible, but the European directive is more stringent for granting anonymity. So this aspect should be properly regulated. And this is a focal point because I think that a few days ago, our National Data Protection Authority issued a sanction of around 40,000 euro against a public entity, and health public entity, an IT provider, for violation of the GDPR regulation, because the whistleblowing web application that was based on an open source software was through system that had not been correctly configured. So that system allowed the possibility to record and storage the personal data of the navigator. So it was possible to identify who was having access to the whistleblowing system and therefore identify the whistleblower. So the technology under the informatic tool is a key aspect for the compliance to the directive. And as other main challenge, I see also the need to identify which are the external reporting channel for both private and public sector, and in particular the role of the trade unions that at the moment in Italy have a marginal role in the whistleblowing matter. Most important challenge, I see also the need to give coherence to the complexity of all legal aspects that are behind the whistleblowing reporting after and during the report. Just think about data protection matter and record keeping, but also labor law aspect and the collection of evidence during the investigation phase. At this respect, consider that in Italy it's possible also to have a conflict with other rights. For example, there is a decision of our Supreme Court that gives priority, for example, to trade secrets instead to the right of the whistleblower, because the whistleblower was sanctioned for revealing trade secrets because he collected some evidence in a preliminary phase before the reporting as to verify the validity, the merit of the report, and he was sanctioned for revealing trade secrets. So it's very difficult to find a balance between the laws and also the court decision. So we have a lot to do, not only from a legislative perspective, but also in terms of court decision. And in Italy, it will be also crucial to define the whistleblowing system in the medium and small companies that, as you know, are the majority in our country. In such context, the whistleblowing system has a difficult implementation because the number of the employees is low, and therefore the confidentiality is more difficult to protect. In a recent report of our national authority, anti-corruption authority, ANAC, it was reported that there is a decrease of 45% of reporting, of whistleblowing reporting from 2018 and 2021. So we have a whistleblowing system that needs to be developed in Italy. We are in a very preliminary phase, notwithstanding in the public sector, this system is mandatory from 10 years. And I think that while we are waiting this, the transposition of the directive, including a small and medium company, the companies shall prepare themselves to this path and to the transposition with possibly a change of mind across the whole chain of value. I mean, from the top management to the employee, and with a great effort in terms of communication and, of course, training. Okay, thank you. I give the floor to my Spanish colleague, Almudena Jurero. Thank you.
Thank you. Thank you so much. And thank you, everyone, for inviting me to this webinar. In Spain, we are also in a preliminary phase. We started the process of transposition just 2 months ago on 4th March, when the Council of Ministers approved just a preliminary draft of a law that tries to regulate the protection of persons who not just report general regulatory infringements, but also this Spanish draft focused on the whistleblowing lines as an element who can help to fight against corruption. This is especially pointed out in this preliminary draft. Regarding the main difference between the directive and this draft that we have in Spain, that it's expected to be approved in the following month, and we don't know exactly if it's going to be during the process in the Parliament some amendments or not, or this could be in general terms similar to the final version. We should pay attention to the following aspects that differ from the directive. First of all, we have wider the scope of the application of this directive. In that sense, our preliminary draft extends this scope, including serious or very serious criminal or administrative offenses, or generally speaking, any breach of legal system which directly affect or undermine the general interest according to this draft, or cannot have a specific regulation and infringement, and also the infringements of labor law in the field of health and safety at work. As you can see, it's a very vast scope, including different offenses. Especially, we would like to focus on the criminal offenses, because it's important to highlight that according to the Spanish Criminal Code, legal entities in Spain will be held as criminally liable for a close list of crimes, not just related to corruption, but also related to money laundering, fraud, crimes against the environment, among others. On the other hand, and trying to protect some confidential information and some sensitive information that some stakeholders point out that it was important, it is stated in this preliminary draft that that this protection will not apply to information affecting classified information, either the information which is related to the obligation resulting from the duty of confidentiality of some professions, such as, of course, lawyers, but also doctors or state security forces and corps as police, or any other information when it could be protected for some specific regulations. So from our point of view, this is an important difference, trying to also protect the secret, the confidential information of very specific files. Other specification of our draft, in contrast to the directive, is that all public sector entities should be obligated to have an internal information system, a whistleblowing line, regardless of the number of applicants or employees that they have. It is compulsory to all public entities. Another specific request of our draft is the creation of an independent authority for the protection of whistleblowers that should be attached to the Ministry of Justice. It should be a public authority, but with independent features. As you know, nowadays our society demands a higher protection of the whistleblower. So for achieving this aim, according to this preliminary draft, once again, we shall create this independent authority. Finally, two more points to put our attention. First, and related with the initiation of an investigation, it's important to say that anyone who commits an administrative offense, so criminal offenses are excluded, as we said before, criminal offenses regarding legal entities has its own criminal regime. So these administrative offenses that shall be reported before the initiation of the investigation of or the sanctioning procedure can benefit from the clemency program and be exempted from compliance with the possible sanction if certain requirements are met, including, for example, the following: having previously deceased to commit the offense, and permit and help to identification of other offenders, cooperate through the investigation procedure with the authorities, provide important relevant information, evidence, and data that can help to the investigation, and not disclosing to third parties the information given to the authorities, and help to report the damage caused for these offenses. And finally, the sanctions that this preliminary draft is considering are basically fines that will be graduated according to the nature of the infringement and the circumstances of the case will be specified in this preliminary draft. As I said before, this is just a draft, and it could have some changes to the final version. But in Spain, we are working with the key elements, key ideas, to adapt and to transform internal policies of entities, of companies, to adapt them to this directive and our local law. And then I pass the floor to my colleagues of Netherlands.
Yes, thank you very much. I'm Frans van Koppenol. I'm a lawyer in the Dutch KPMG legal team. And in the next few minutes, I will update you on the situation in the Netherlands. First of all, in the Netherlands, we're still busy with draft legislation. So the actual law that should be based on the directive is not in place yet, but there is existing legislation in the Netherlands in respect of whistleblowers. And I think now knowing the contents of the directive, that you could call it a bit of a light version of what the directive aims to do. So it also has the obligation for companies to install a mechanism where employees can report if there's any misconduct. But again, it's a bit of a light version. There are less details than there are in the directive in terms of what these processes should be. Important part of the existing legislation is that the employees first have to always use the internal channels to make a note of any misconduct, and only after that they can go external. So that's currently in place. So when doing business in or with the Netherlands or in any Dutch respect, keep in mind that there is already legislation, just not yet fully based on the directive. If we look at the draft legislation in the Netherlands, then it makes sense to highlight a few of the elements in that bill. It will be no surprise that many, if not all of those elements, have already also been mentioned by my colleagues. Obviously, each country has the freedom to make the draft law as it wants, but within the options that the directive has. So I'm going to quickly go over them. Well, before that, actually, one remark. The government employees are, in that sense, not that much bothered by the actual status of the draft legislation, because the measures as set out in the directive already reply to every government entity. So it's for the non-government employees, and then obviously those that fall within the scope of the directive, that it makes sense to keep track of what's currently in the draft legislation. I think the first one, which is quite different compared to some of the other countries, is that the draft legislation does not contain a fine if companies do not adhere to their obligations to put a whistleblowers mechanism in place in their company. Obviously, when the draft law has come into law, there is an obligation for companies to actually do that, and employees can actually go to court to make sure that that the company actually does that. But again, there are no fines involved. Currently, the draft legislation does not make a distinction whether it can be done on a group level or an individual company level. Of course, that is something to keep in mind. If you're involved in a group, it may make sense to look into this in more detail. But again, unfortunately, at the moment, the text of the draft legislation just imposes the obligation on any company in the Netherlands that meets the criteria, and does not say whether that can be done on a group level or not. I mentioned the sequence in the current law. In the draft legislation, it is also possible to directly go to the external government reporting channels. I can imagine that that's in particular interesting if there is no internal channel or if that's not done correctly. Actually, and this is also a bit different, I think, than some other countries are currently doing it, but similar to other countries, there are quite some external reporting channels in the Netherlands, because it was chosen to have the approach that it is based on the expertise of the channel. So to name a few, we have the Authority for Consumer and Market, the Dutch Authority for Financial Market, the Dutch Data Protection Authority, the Dutch Central Bank, Dutch Whistleblowers Authority, and many others, stemming from the idea that a whistleblower needs to go to a authority that actually also knows what they're talking about. So the idea would be that if you want to disclose a misconduct in terms of financial markets, you should go to the Authority for the Financial Markets. If it has to do with consumers, go to the Consumer Authority, etc., etc. Then last, a comment on the status of the draft bill is that currently, as in other countries, as we have seen in the preceding slides, there is an extension of the deadline for small businesses between 50 and 250 employees. Then if we have a more detailed look at the special requirements that the law imposes in terms of the reporting system, again, this is much more detailed than the current legislation that we have in the Netherlands. Obviously, again, in line with the directive, it's an overall detailed instruction of which the most important elements are that a company should have procedures for internal reporting, a list of the independent channels. I just mentioned a few of them, and obviously which are relevant probably ties to the business that the company is in. It should contain an explicit reference that the employee is allowed to confidentially consult an advisor, and the confidential part of the whole reporting is an important part of debate in the Netherlands, and actually something I will briefly give a very recent update on at the end of this brief presentation on the Netherlands. And there should be a procedure for internal reporting, where a big difference with the current legislation is that there should be a register and information how the employee is protected. Important note on the Dutch transposition is that within the options of the law, the Netherlands have chosen to not make anonymous reporting mandatory. So that means that a company can have a reporting mechanism which does not allow for anonymous reporting, and then adheres to the draft legislation, assuming, of course, that it will enter into force as it currently stands, which is not entirely probable, actually, as we will see at the end. And it also notes in the Netherlands that email is a valid reporting channel under the draft legislation. Then wrapping up with some of the other legal requirements, when setting up the internal reporting system, the Works Council needs to be involved. If a company works also with non-employees, so you can think of independent contractors, it should be open for them as well. Non-disclosure clauses in employee contracts are disregarded when an employee is making a valid reporting under the law. And as I earlier said, there are no fines, but an employee or the Works Council can request the company before the court, if necessary, that a company set up the required reporting system. Also in the Netherlands, no specific mentioning of data protection, so we all assume that the typical rules of data protection apply, probably with the employee disclosing information with a legitimate interest in terms of reporting, getting a bit of a light version of that. Then as a final note, as I mentioned, very recently in the Netherlands, the draft legislation was topic of debate in Parliament. And that stemmed from the fact that one member of parliament, also reviewing the fact that the current legislation in the Netherlands is not working that well. Actually, there are not a lot of reports, and actually the reports made in the Netherlands typically don't end well for the whistleblowers themselves. Part of the debate was a note from this member of parliament, which in general encourages to include better protection for the whistleblowers in the draft legislation. To give two examples, the Member of Parliament urged that it would be mandatory actually for companies to have a unanimous reporting line, stemming from the idea that it typically doesn't end well for whistleblowers, unfortunately, looking at the past in the Netherlands. And also the second example of those 15 suggestions to extend the scope of protection also to the family members of the whistleblowers. Obviously, this is currently a topic of debate in Parliament. I don't expect that all 15 suggestions will make it into the law, but it does show that it is currently a hot topic in the Netherlands, and also that the draft legislation is probably not going to enter into force in its current form, as I would expect that some of the suggestions will actually be included, which means in general that the protection for the whistleblower itself will probably be more heavy in the legislation when it enters into force than it is in the current draft. That was the sum up for the Netherlands. Thank you, and that also sums up the country summaries. And then we go now to the system presentation. Thank you.
Thank you very much, Francois, for your provision and the update on the Netherlands. So I will take over here. With regards to the time, I think we do the very short version. So let me just, oops. Now it's moving. This is so. Please do not click on the slides. The other ones. Thank you very much. Regarding a system, a whistleblowing system, let me make it very short. So whatever your organization is like, whatever your requirements are, you are trying to address with a whistleblowing solution from a technical perspective to comply with the EU directive. You can be assured that the solutions that we as AQS are providing help you to fulfill the requirements fully. So if you have already installed one of our solutions or you're planning to do so, you're definitely on the safe side, on the secure side, using a certified system that provides security to you in terms of IT security as well as GDPR compliance. And it's coming from the leading provider in this field. So we're serving more than 2,000 customers across the EU and worldwide. So whenever you want to find out more, please talk to your contacts at AQS if you're an existing customer in either key account management or the customer success teams or to our sales colleagues. And with this, I would actually like to just go back tonight so that you can see the speakers again, and then let's take time for some of the questions that have come in via the chat. Thanks already to all the participants for providing these questions. Maybe addressing Bernd Federmann with an initial one, because this is somehow in the topic in some of these questions. Maybe we can start with one question, Bernd. What law actually applies to me? This is something that seems to keep quite a lot of people busy. Yeah? So if I'm a Spanish company, is it just the Spanish law once transposed that affects me? Or is it the German or the Austrian law if I have entities over there? So this is obviously still confusing for some. Maybe you can shed some light on this?
Yes, thank you very much. Simple said, the law where your company has the seat applies to you. That means if you have subsidiaries in Austria, in France, the French, the Austrian law applies, irrespective if you have the headquarter in Spain or in Italy. So you have to fulfill the requirements of the local laws each. That is the answer on this. And I saw another question, when does Switzerland and other non-EU countries do have to implement it? In principle, they do not have to implement as they are not covered by the EU framework. So in other countries, there is no duty to implement outside of Europe.
Yeah, thank you very much. That was very clear. Let me just add one aspect. If you are a Swiss company and you have legal entities in any of the EU member states, then you will still have to comply with the legislation in each of these member states, right? So it's kind of an indirect obligation.
That is absolutely correct. Absolutely correct. And as whistleblowing systems are also an important hallmark of a compliance management system, and you have it in your group in other countries, then the question arises, why do you not supervise your compliance with a whistleblowing system in your home country as to compliance aspects, not as to a duty of law? So that might also lead to the conclusion also in Switzerland, according to the obligation to supervise the compliance system to implement such system.
Wonderful. Very clear from my side. Thanks for this one. Let me pick another aspect that was brought up. So it's maybe a split question a little bit. So on the one hand, it was asked, what are the sanctions if I do not implement a whistleblowing system? So national legislation obliges me to do it, but I say, I won't do it. So what are the sanctions I might be facing? And in addition to that, how often, a very interesting question, by the way, how often can a fine be made for not implementing? Yeah? So if I don't do it, I'll be fined once, or if we be fined again and again and again.
Yeah, absolutely right. One point, the EU directive demands the national laws to foresee for sanctions. That means that is not a sanction on the EU level, that is sanctions on national levels. That means every country may, on its own discretion, put up the sanctions. So that are mostly administrative sanctions. And there are certain aspects which are sanctioned. For the one hand side, not to implement a whistleblowing system at all. And on the other hand side, more grievance for the hindering of giving hints for whistleblowers. That is the other hand side. And when you have the duty of implementing whistleblowing system, and that is a fact of omission, and if you are convicted sometime or sentenced by a court with regard to this omission is interrupted. And after being sentenced, you do not implement such system, then you have opened the chance to again being sanctioned for this omission, not to implement a whistleblowing system. So you cannot say, well, I wait for one sanction and then for 100 years I do not implement it. If you are sanctioned and you do not implement it, that is a normal principles of criminal law principles, then you again will be sanctioned for the further not implementing the whistleblowing system. That is what I would judge on this.
Yeah, thank you.
I don't know very much how the case is in the other countries, but in Germany, according to the principles, this should be the case in this respect.
Yeah, but maybe we can add to this. So I hope it's just a theoretical question out of curiosity, because anyhow, the recommendation is still clearly that implementing a whistleblowing solution is anyhow the right decision, right? So the EU directive was made for good reasons. Whistleblowing is well established since nearly 20 years. It's best practice to have it. And we even see that it becomes more and more kind of a question when you're recruiting well-educated, well-trained people. Yeah, so it's this competition on experts that we see on the labor markets. Then a compliance system, including a whistleblowing channel, a whistleblowing system, is something that people start to ask for. So better implement a system than not implementing it and trying it out. Cool. Very practical question was made. Not sure if you have an answer. So the question was, is there any place where each of the national legislations would be available in English language? So kind of a collection of those.
Not to my knowledge. We have the KPMG Integrity Service in Europe with all KPMG offices who collect. Yes, that is here, but it is also a moving target. Yeah, it changes from week to week, the situation. And I do not know about one platform where you see all the texts in the current versions. I don't think that it is available. I don't know it. Perhaps someone in the circle here knows better than me, but I don't know. It's a moving target.
Yeah, I can definitely say I'm not aware either, even doing some research trying to find it, and sometimes it's even hard to find one of the national legislations in English language at all, right? Sometimes it's just in local language, at least at this point. But we'll observe it, and I think we can promise if we find a source, we are happy to share the information, because it's interesting for many here. Then let me see. We had another webinar last week that was dealing with requirements for groups of companies, so sharing systems, own systems, or central systems for larger entities, and so on. So you can find it on the EQS web pages, looking at former webinars, including a recording. So I would recommend this, because we had some questions coming up around this topic, but that's a very broad one. I would not want to open up now. So let me maybe pick one more question that just came in. There is a German law on the supply chain that will come into force beginning of next year, 1st of January, for the large companies, 3,000 plus employees. 1 year later, the smaller ones, 1,000 plus, and EU regulation is on the way as well. And some other member states are currently working on something. And there was a question, overlap between these supply chain legislations that would include something like a grievance mechanism and the EU whistleblowing directive. I think the question is, how do these go together? Can I establish a whistleblowing channel that would allow me to comply with the other legislation automatically?
Not exactly automatically, but to combine the both channels and case handlings absolutely makes sense, as there are cases which are both where both legislations do apply to, and which are in other cases which have to be regarded separately. So short said, according to the time at the front end, it makes absolutely sense to have the same channel, and the back end you have to differentiate a little bit how to handle the cases. Not each case of the Lieferketten-Sorgfaltspflichtengesetz supply chain, Article 9 of the EU directive, the future EU directive, or Section 8 of the German law, not every case is a compliance case to be handled. However, it might also be a compliance case in this respect. So back-end differentiating, front-end, you should, as to our opinion and our experience, have one channel which covers all these topics. That is a practical solution.
Thank you very much. I can again add to this. So we are currently talking to really a lot of our customers who have exactly this question. So they have already a solution in place, looking at the, let's say, typical compliance perspective. And now the supply chain law comes into place, and it can easily be adopted, as Bernd explained. So you can enhance it. You can have some specific processes around the human rights, social standards topics of the supply chain law within the same system. So it's enhancing what you have, but you do not have to implement something in addition to it. Wonderful. So with regards to the time, let's just take one last question maybe. So there was a question asked looking at the current German law that, for example, would allow or would open up for still continuing to use a central system and not being in the need to probably set up separate systems for larger entities. Can we expect that the EU will take any measures against Germany if this draft becomes the law in the end? Because there is a different opinion, right, from the Commission's point of view.
There is perhaps a little bit a different opinion. However, it is very intelligent structured, the law, though, so that this is not contained in the law text itself, however, only in the explanatory notes, so that is can be interpreted. Yeah, you need the explanatory notes to interpret it, and therefore I can say what the EU Commission says on this. However, it is made maximum difficult for the EU Commission to go against this as far as this is it possible. So that is my view on this, and therefore very intelligent solution from the lawmakers. However, I saw also a question with regard to Spain. Perhaps, François, you can say about the group situation in Spain. I also saw this in the chat.
Yeah, I can't say that much about Spain.
Sorry, the Netherlands. I saw. Order?
Which?
No, actually the question was related to Spain, so does Spain allow a centralized system?
Yeah, no, I think it's the same in the Netherlands, and what you exactly need to do is not that clear actually yet from the draft legislation.
Yeah, I think this is definitely the challenge that we're currently seeing, right? Because there is slightly different perspectives from member state to member state. There's a perspective from the EU's level, and we just will need to wait and see how things develop. I think that's probably the fairest answer to this. All right, so 5 minutes after 12, I would say let's end up for today. A big thank again to all the speakers, to all the experts from the KPMG Law. Thanks for providing your expertise and insights into the topic. To the participants, I hope you found it interesting. So we had really a lot of participants in this webinar, and everybody seemed to stay for the whole time, even if with 90 minutes. It's rather a long one. But I hope you have valuable information that you're taking away. If you're interested to receive the slides, we are happy to provide them. Just drop an email to me, and we will take care that you get access to the slides. And whenever you have any further questions, want to get in touch, there have been, I think, 2 or 3 very specific questions from Italy, where in this case, I'm happy to liaise you with the KPMG colleagues so that you can follow up on these. And whatever else questions you might have afterwards, just feel free to contact me. So thanks a lot. Take care, enjoy the hopefully sunny weather and late spring, early summer, and see you soon in one of our webinars. Thank you very much.